Home, I want to bring in my guest for this hour, national trial attorney, friend of the program, Michael Jaafar. Michael, nice to see you on this busy Tuesday. When we're talking about this case, it may be redundant information for this jury, but it's very important to show that these cell phones are moving together.
Absolutely. The prosecution has to prove their case in two big stages here. One of the big stages is showing that he was there, that he was part of the events, and they're doing their job. They're doing exactly what they need to do. They're doing it. As a matter of fact, I don't even think the defense really is going to try to challenge this. I think the defense only has one Hail Mary defense, and that's that he didn't know that this was going to happen. So I don't anticipate the defense really fighting this information. It'll be interesting to see how they cross-examine. But right now, I agree with you. They're doing exactly what they need to do, the prosecution.
What are your overall thoughts on this case? I mean, there are co-defendants that this jury has heard about. One is prosecuted, the other one still waiting for his trial, but just really gory details in the planning and the murder here. What are your overall thoughts, and what might you be watching for?
I always analyze these cases as though I was a defense attorney. If I was a defense attorney on this case, I would be fighting one thing: knowledge and liability. If this case were taught in law school, the theme of this case would be accomplice liability. It's a very big thing you learn as a young lawyer, whether or not your client, the defendant, knew what was going to happen. In Iowa specifically, if his defense attorneys can prove, yeah, he helped him, he bought the machete with him, he drove Hoffman there, but he had no idea that Luisma was going to kill her, then he will be acquitted of these charges. The prosecution has to prove that not only was he there, but he actually knew that Luisma was going to do the monstrous act of killing her. So they have to prove this. If I was a defense, I would be fighting everything I can. Perhaps, maybe, I don't think they're going to be able to get Luisma to testify and say he had no idea, because Luisma wants to have an appeal. But maybe there's a text message from Luisma to Van Patten saying, hey, don't worry, I need to argue with her, I need to talk with her. That's the whole entire case, is whether or not Van Patten knew what was going to happen or not.
Do you put him on the stand?
I would have to. I would have no choice. I've done this more than most of my colleagues. My record at trial is very, very, very good, and I've put many, many defendants on the stand. You got to walk the plank. If the jury's there, they see you, you got to walk the plank, you got to tell them your story. I would put this particular defendant on the stand.
And this defendant would have to explain away all that circumstantial evidence, including having the victim's glasses and taking more than 200 photos, selfies, after the murder, according to prosecutors. All right, Michael Jaafar, you're going to be sticking with us all hour long. Thank you. Still with us, national trial attorney Michael Jaafar. Michael, what stands out to you from this witness?
They basically shrunk the timeline and the geography, and they put these people, the Van Patten with Luisma, in league with this grotesque murder. So he did his job. He did exactly what the state wanted him to do, which is, it's incontrovertible now that Van Patten was there. And so I think they gave themselves the foundation to overcome the final hurdle in this case, which is what did Van Patten know was going to happen, and then it's a wrap at that point.
Right, because that's what the defense is here in this case, right? It's that, not the fact that he wasn't there, they concede that, but it's the fact that, maybe he didn't know what was going to happen and did not participate, according to this defense.
Yeah, that's exactly what their defense is. That's what their defense has to be. And look, it's a big burden. The state has a big burden. They have to prove that Van Patten actually knew what was going to happen, as opposed to just being some stupid, dumb kid going along on a ride with his buddy. Here's what the defense is going to say. How many kids, all of you in the jury have been kids his age, how many of you got in a car with your friend on your way to confront somebody and you thought that they were going to murder somebody? How many, if I was a defense attorney, that's how I'd lay it out. How many of you have been on a joyride or a ride with a buddy at his age when they were going to confront somebody and then they ended up murdering that person, right? So that's going to be the defense, and let's see what happens.
Yeah, is that where you would go with putting on a defense, or maybe even highlight that in your closing arguments? Is the age here?
Yeah, absolutely. No questions asked. Your frontal cortex is not developed until you're the age of 25 to 27 as a young man, right? Up until the age of 25, you make dumb, stupid decisions. Your frontal cortex is like a raging storm. This is just science. It's not my opinion. And so I would say, how many of you have done something dumb and stupid when you were a kid? It just didn't end up in somebody that you were doing that dumb thing with, ended in a murder. I would absolutely go down that road. If this was a 47-year-old man and he saw his buddy commit a murder, he'd pick up the phone and call the police. That's what my defense would be, my closing argument would be to the jury.
Yeah, and you mentioned this before, but maybe for the viewers that are just joining us, why would you be preparing him to take the stand, and why would you be recommending that? Of course, it's only the defendant's choice.
Oh, I absolutely recommend it, because you can't sit mute when you're facing charge with murder. When you're facing those charges, the jury has to see you speak, and you can only make them like you by speaking. By them seeing you silent, their imagination runs wild. You absolutely, because it comes down to your intent, what you believed. Anytime a case comes down to the intent of the defendant has to take the stand and tell them what their intent, what their knowledge was. It has to happen, in my opinion.
Michael Jaafar, thank you so much for being with us. You at home, don't go anywhere. Get this, opening